In today's video blog, I would like to visit the issue of the duty of a landowner to people who come on the property. This could be a commercial landowner, or it could even be a private property owner. And the courts in Massachusetts have been very clear as to what is expected in terms of the duties of the landowner. And the bottom line is a landowner has a duty of reasonable care to anyone who is entering onto the property lawfully. Now, I'll have to take you back some 40 years to a very important case in Massachusetts called Muncie v. Ellard. And in 1973, the highest court of Massachusetts, the Supreme Judicial Court, did two things in that decision. It first abrogated or canceled the distinction that had existed in the so-called common law among invitees, licensees, and trespassers. What the court did is it basically created one category among licensees and invitees. The court said all those lawfully on the premises are owed a duty of reasonable care. Trespassers continued to be treated differently, and the landowner had a duty to refrain from wanton or willful misconduct. So that abrogation between licensees and invitees has been very important, and it basically means, again, unless you're trespassing, you have a right to expect that the owner or occupant of the property will treat you with reasonable care. So what constitutes reasonable care? Well, that's often, there are standards, and it's often a jury question, or as cases commonly settle, it's a distinction, or it's a conversation that, of course, your attorney has with either a defense attorney or a claims person as to whether that duty of reasonable care was met. There are guidelines that there would be testimony to, and so on and so forth. Reasonable care, by the way, is not the highest duty of care, and judges are quick to inform jurors of that. In fact, they say a landowner is not an insurer of the premises. I must tell you that I find that kind of interesting because there's such an effort in the courts to not mention the word insurance, but nevertheless, I've heard several times that instruction used. The meaning of that instruction is that just because an accident happened is not necessarily compensable. The mere happening of the accident will not give rise to liability. Rather, there has to be negligence and what we call proximate cause. By the way, snow and ice cases are a form of landowner liability, and we will visit that in a later blog. But some of them, or at least historically in Massachusetts, they have had some unusual requirements, and I would rather not visit that within the confines of this blog. One thing that is important to note is this Doctrine of Muncie, which we've had for over 40 years in Massachusetts, does not distinguish among, say, a police officer coming on the land to do something with regard to the property, nor is a worker who's coming on the land to be treated any differently than, say, a visitor or someone going into a store, or if it's private property, somebody to come over to visit socially, or somebody to come over to have a more professional type of conversation. Again, there is no longer that distinction as to the class or the category of person coming on the property, and there is that standard that must be met or overcome if you are suing, and that is that there was a failure or a breach in the duty of reasonable care. Thank you.